Now we get a chance to look behind the curtain to see how pretrial justice and bail reform fit into the American Civil Liberties Union broader vision to end mass incarceration and the over-criminalization of people of color. I would like to introduce Andrea Woods, staff attorney with the ACLU's Criminal Law Reform Project focusing on pretrial justice. She's currently litigating 4 constitutional challenges to systems of wealth-based detention on money bail in federal courts in Dallas, Randolph County, Alabama, Cullman County, Alabama, and Glynn County, Georgia, where she's lead counsel. Andrea also co-wrote the ACLU's National Strategic Plan for Bail Reform and consults with ACLU staff across the country regarding bail reform policies. Please give Andrea Woods a warm welcome.
Thank you very much, Jeff, and thanks all of you for having me here today. Before speaking a bit about the work I currently do in the bail reform movement, a movement that's dedicated to reimagining pretrial processes that's also supported very deeply by the work that you all do, I am mindful of the fact that to many or most of you, I am a new face. I am also mindful that I'm here to speak about pretrial reform to a group of people intimately familiar with pretrial systems and processes. Just as you have all come to your work influenced by the experiences of your lives, informed by the struggles you've seen your clients and community members face in navigating the criminal legal system, and instructed by the guidance of your teachers and friends, so too have I. To give you a better sense of how I come to my work and who I am, I'd like to take a little time and introduce myself to all of you. My journey as an advocate for widespread criminal law reform began nearly 10 years ago when I worked for an organization dedicated to sharing the stories of people who had been wrongfully convicted, sentenced to death, proven innocent, exonerated, and finally freed. This organization, called Witness to Innocence, lobbies to abolish the death penalty by centering the voices of people who have survived this unthinkable nightmare of being condemned to execution for a crime they did not commit. When I worked at Witness to Innocence, I was making $400 a month, and our office was in a small room in a church basement pantry closet. You had to go through the pantry to get to the closet. While there, I was planning retreats for our exoneree members and their families, and I booked speaking engagements for them to share their stories for colleges, churches, and community groups. Survey data that we collected at Witness to Innocence led us to understand that nothing changes attitudes towards capital punishment quite like hearing the stories of people who've been exonerated from our nation's death rows. Today, there are 162 such exonerees, though I'll note that that is a conservative list. That list is limited to people who've been able to legally prove their innocence through very narrow available legal pathways. There are countless others. These survivors of death row were my great teachers. Delbert Tibbs, Kirk Bloodsworth, Derek Jameson, Freddie Lee Pitts, Ray Crone, Nate Fields, Ron Kiney, and others opened my eyes to all that can and does go wrong in a culture so built on punishment and on fear. Many of my friends who went through this unimaginable ordeal lost parents and family members during their wrongful incarceration. Many of them were too traumatized to adjust back to ordinary life after their release. They couldn't operate unfamiliar technologies like a microwave, let alone hold down a steady job. Several of them came within hours of execution. At the time, working with these survivors and advocates, I thought how astonishing it was that my country had been so wrong in so many of their cases. Years later, after my relationships with these men inspired me to attend law school, I found myself working at the Alaska Public Defender Agency, representing our clients at bail hearings held each day in the Anchorage jail. The group of clients who awaited me there each morning at 8 a.m. had all been woken much earlier than I had. They were all living in an unconscionably overcrowded institution, many of them forced to sleep on mats on the floor. And they were all very desperate to have their case heard. During these precious minutes of hearing prep, every time I called one of their names from behind the mesh screen and the glass window that separated us, it was apparent that this client was angry, was anxious, was confused. Amidst the chaotic dance that included introducing myself, gathering details relevant to their bail request, and eyeing the clock and the impatient judge in the jailhouse courtroom, the most palpable and important message that I heard from these clients was very simply, "Get me out of here. Get me out of here. These charges are ridiculous. Get me out of here. I'm about to lose my job. Get me out of here so I can care for my parent or my child. Get me out of here because it's dangerous here. Get me out of here. I need medical help." The requests, though particular to each individual, were uniform in their fervor, separating my clients from either an indefinite stay in jail or their ability to be with their families and to maintain their jobs was a seemingly simple and yet incredibly oppressive hurdle: the requirement that they pay an upfront amount of money bail that they simply could not afford. I saw clients lose jobs, miss family funerals, and be victimized by violent assaults during even seemingly short periods of time that they were incarcerated on bail. I represented one man who had been assaulted while he was in custody, and when he stepped up to the podium to begin his bail hearing, the judge refused to hear his request for reduced bail because of his appearance, because he had bruises and a black eye. I urged the judge to reconsider, noting that his appearance could easily be explained and was in fact relevant to his request for reduced bail, but she refused. Certainly, when I now consider my friends who survived death row, my clients incarcerated in that Alaska jail were facing far less dire circumstances. But the truth is that these two seemingly extreme ends of the criminal justice process rest on the same foundation. That foundation is our culture that criminalizes poor people and people of color, that assumes the worst in everyone accused of a crime, and that is far more equipped to offer a jail or prison bed than desperately needed social supports. In my work in that Alaska jail and in my current work challenging inhumane and unconstitutional bail practices across the country, I see decisions that are just as arbitrary, just as racist and classist, and that treat people with just as much disdain and disregard as the many decisions that led to my friends being wrongfully convicted and then sentenced to death. I now work, as you've heard, for the American Civil Liberties Union in its criminal law reform project. My work is devoted to reforms on the front end of the criminal legal system, and particularly on bail reform. I bring and contribute to federal lawsuits challenging the unnecessary and unconstitutional jailing of people due to their inability to afford bail. I've also supported 2 successful cases challenging impermissibly broad pretrial detention provisions in Arizona. In my work, I've investigated many counties, and I've worked with state ACLU affiliates in dozens of places. Over the years, as I've worked in these movements to end mass incarceration, cease our dependence on money bail, and abolish the death penalty, I've come to understand something that you may all very well see playing out in your work. Treating people like criminals is criminogenic. Put differently, our culture of punishment and fear creates a self-fulfilling prophecy. Thank you. Delbert Tibbs, who was one of my personal heroes, was sentenced to death in 1974, despite differing from the physical description of a rape and murder suspect in dramatic ways. His height, his hairstyle, and his skin tone were all very different. An all-white jury took less than 2 hours to deliberate and sentence Delbert to die. After his conviction was overturned by the Florida Supreme Court, even the prosecutor who handled his case admitted the whole investigation was tainted, and that were Delbert to be retried, he would testify in his defense. Delbert spent the rest of his life bearing witness to the horrors of the criminal justice system and death row. He also dedicated his life to his poetry and his children. He kept a vegan diet and once confided in me that he didn't even step on bugs if he could help it. The knowledge that we almost executed someone as generous-hearted as Delbert haunts me. It drives my continued work to this day. I'll never forget the summer that I got to know Kirk Bloodsworth, who was also wrongfully convicted and sentenced to death, in his case largely because he looked so much like a drawing rendered by a police sketch artist. Kirk spent 9 years living in an alternate reality because members of his community, the victim's family, and prison staff all believed he was a monster. He started to believe it too. Even after he became the first person exonerated from death row by DNA evidence in 1993, he would see his own face in the mirror and see something less than human, a monster, because that was how the world saw him for so long. We treated Kirk like a monster for all that time, and it's a testament to his resilience, the support of his community, and a lot of luck, not the legal system, that he has recovered psychically and emotionally. Others were not as lucky. Just before leaving Witness to Innocence, I attempted to track down the 100 or more death row exonerees who were not active members of our organization. What I found was that an overwhelming majority of them were dead or in prison. They had suffered too much. The ordeal of being subjected to such violence, to being treated for so long as subhuman, took a natural toll on their ability to live healthy and stable lives. My current clients, Marjorie Mock and Eric Ogden, were making ends meet off disability survivor benefits and were without stable housing when they were arrested for allegedly trespassing while trying to visit a relative. When they were arrested and each held on a $1,200 bail, they couldn't afford all of their belongings, were in a storage unit, which was also their only place to stay. Because between the two of them, they didn't have $2,500 to post their bond, they were left to worry about losing all their belongings and wondering who would care for their family and for their pets. Another one of my clients, Robert Cox, has spent over 170 days incarcerated over the past few years due to his inability to pay bail on various low-level misdemeanor charges. One such arrest was for allegedly stealing 2 bottles of vanilla extract valued at $16 total. Lavette Mays spent 14 months incarcerated due to an unaffordable bail requirement, leaving her and her children in total limbo. Lavette is herself a powerful storyteller and advocate, and so I'd like to share a short video of her telling her story to all of you.
I had been up for like 3 days. I was extremely fatigued. Hair wasn't combed. I still had on my nightgown. When the judge told me my bail, I almost fainted. I couldn't move. I've lived on the south side of Chicago all my life. I have 2 kids. My son is amazing. He gets along well with his sister, but of course he's 5, she's 14. He feels like I'm in the house with 2 women. Sometimes he say, all I want is just peace. And we'll just look at him and laugh and say, did you hear what he just said? I was going through a divorce. A lot of things got bitter, and I had an altercation with my mother-in-law. I had no inkling that I was going to be arrested because I didn't start it. I was defending myself. After 3 days of lockup, I was taken to court. I remember going there and it sounded like you're at an auction. You can't talk to the judge, you can't say anything. Just stand there, put your hands behind your back. The judge assessed my bail at $250,000, $25,000 to walk. I'm like, I don't have a background. I've never been to jail. You know, why would my bond be so high? I'm 46 years old, and my entire life was determined right there within 30 seconds. I was in jail for 14 months. I lost my business, my housing. I couldn't see my kids just because I couldn't make bail. In the end, I took a plea. Not because I didn't think I could beat the case, but because I needed to be with my children. They had already suffered enough. I don't think that society is really understanding when you incarcerate women, you're incarcerating the whole family.
What I've come to realize, the more time I spend engaging with our country's criminal legal machine from various angles, is that the messes that were made of the criminal prosecutions I came to know so well through the stories of Delbert and Kirk and others, those messes were not astonishing. They were a perfectly logical symptom, given the foundation I just spoke about, given a foundation that is racially charged and drives fear, punishment, and debilitation. In a world in which we see our neighbors and community members as threats rather than people worthy of support, in which judges and prosecutors have to cater to those fears to keep their jobs, and in which we've yet to do a real reckoning with systemic racism, there are going to be casualties. The horrible tragedy endured by the Browder family is one powerful example of the tolls this system exacts. Now that I understand that to be true, I have a far wider view of what a wrongful conviction looks like or what unnecessary incarceration means. I appreciate that we are very bad at addressing and mitigating violence, and I appreciate that it is very illogical to use incarceration as a tool to advance the goals of a safe and just society. Research confirms this. The Vera Institute has explained that there are 4 main contributors to violence. 1, isolation. 2, shame. 3, an inability to meet one's economic needs. And 4, exposure to violence. And look what happens when we incarcerate. We isolate, we shame, we make it all but impossible to meet economic needs, and we expose people to violence unimaginable to many of the rest of us. We are beginning to acknowledge that Black and brown people are disproportionately subjected to this ideal. What we talk about less is that young men of color are also far more likely to be victimized by crime and violence in the first place. And so trauma and pain begets trauma and pain. I share all of this because it reminds me how high the stakes are to do our collective work and reform these practices and envision something different. Any exposure to jail exacts a grievous cost on the person jailed and their family. As has been noted by researchers in this field, a serious disruption in a person's life begins within 1 or 2 days of being in jail. When upfront bail payments are required, this is easily the amount of time someone can spend, even if they're eventually able to come up with the resources and pay. And many people can't get out in those first few terrible days. The Federal Reserve recently noted that 4 in 10 adults in the United States could not cover an unexpected $400 expense without borrowing money or selling something. Thus, these upfront bail requirements force people into jails and keep them there, with terrible implications for their well-being, for their families, and for their cases. As you likely know, controlling for other factors, incarceration prior to trial is the #1 contributor to a conviction. Without the opportunity to meet with defense counsel in a truly private space, without the ability to attend to family, work, and medical needs, and thus wait out the period of time between arrest and trial, we know that people make a calculated choice, like Livette Mays, and plead guilty to end the ordeal. In a study capturing thousands of case outcomes in New York City, the author noted that the misdemeanor conviction rate for people who can pay bail and get out within a day is about 50%. That rate jumps to 92% when people have no way to pay bail and are forced to stay incarcerated throughout the disposition of their case. For all of these reasons, a movement has galvanized around ending our dependence on money bail, ending wealth-based incarceration, and severely limiting our use of jails, especially for people who have not been convicted of a crime. The ACLU is contributing to that movement through my and my colleagues' litigation. By my last count, we've brought 11 legal challenges against the bail system to date. But we're also contributing by organizing campaigns across the country, by educating policymakers, and by deliberately targeting the corrupt $2 billion commercial bail industry that profits off the continued processing of low-income people and people of color through these systems, and which stymies reform efforts. The ACLU is active in approximately 36 states in this fight. Our litigation challenging the incarceration of people on bail requirements that they can't afford has certainly seen some great success, from Georgia to Texas to California and Massachusetts. And there are other viable challenges beyond the unconstitutionality of detention on unaffordable bail. I hope that we expand the success we've seen in Arizona, challenging overly broad detention schemes outright. I hope we continue to hold prosecutors accountable for their roles in these systems. And I hope we can better establish the early right to a public defender to assist with the pretrial release determination. However, we are now seeing, perhaps more than ever, the limits of this litigation. This very month, 2 judges on the Fifth Circuit Court of Appeals went against decades of precedent and flabbergastingly attempted to walk back the fundamental protections against wealth-based pretrial incarceration. Particularly as the federal bench continues to change, the ACLU and our partners in bringing this litigation, groups like Civil Rights Corps, the Southern Poverty Law Center, the Southern Center on Human Rights, and the MacArthur Justice Center, to name a few of our fantastic partners. We are mindful that litigation is just one strategy in this movement, and much else is needed. We will, of course, continue to vigorously litigate our cases, but we will continue to depend on all the other forces for good in this movement to keep pressing towards a different future. The great work of organizers, researchers, journalists, and charitable bail funds all help shine a light on how impractical and how harmful this status quo is. And I'd like to note how essential pretrial service agencies are in this movement, and I'd like to thank you for the incredible perspective that your work offers us all. In considering how we move away from a bail system that violates constitutional rights and exacts such massive human costs, it can be very difficult to think of solutions. When I get down on myself for that, I have to remind myself that the bail system has been around since basically the signing of the Magna Carta, and so perhaps it's understandable that it's difficult. Devising how to build something new and ensuring that that something new doesn't replicate the same culture of fear and bias that our old system rests on is difficult. But the people in this room do give me such great hope. Pretrial services already provide a desperately needed alternative to incarceration. Pretrial services systems already offer an avenue by which we give people chances to succeed rather than all but doom them to failure. In many places, pretrial services models break away from the pay-to-play scheme, and in doing so, recognize the cost of making our justice system fairer for everyone is worth that investment. This is so critical as we move away from such a deeply entrenched system that views detention as the primary risk management solution, particularly for people who can't afford to pay financial conditions. Your work is essential to mitigate the massive human costs of needless jailing. Pretrial services operated with an emphasis on the dignity and the potential embodied in everyone, especially those accused of crimes who have been so very stigmatized for so very long. This represents an aspect of our current day reality worth celebrating, worth investing in, worth continuing to improve. Bringing it to the work that I do, pretrial services provides a very compelling example when I bring litigation. When jurisdictions create systems that impose automatic, secured bail requirements that ensure that poor people will be detained, one of the constitutional violations presented is the failure for that jurisdiction to consider less restrictive alternatives first. You are a less restrictive alternative. Data from systems that utilize pretrial services is an antidote to claims that there's simply no other way. Thank you for equipping my colleagues and me with that data, and thank you for continuing to provide those alternatives. I have to give a special thanks to Spurgeon Kennedy, who I bother like once a month asking for this data and for these powerful declarations. So thank you, Spurgeon. I hope you will all continue to undertake your very important work in ways that are humanizing and creative. Where you see conditions of pretrial release presenting significant barriers to success, please be open to considering changes. And in a justice system founded on the notion that it is better to let 10 guilty people walk free than one innocent person languish in jail, please remember that some risk tolerance is a real and essential part of our collective mandate. I make that plea both as a civil rights attorney and as someone who has herself experienced violent crime. In addition to continuing to partner in litigation and public education, I very much hope that we can be in conversation with one another. Organizations like the ACLU depend on your technical and insider knowledge about what is out there and about what can be achieved. Together, I hope we will keep building a world that receives people accused of crimes with fairness and humanity, that doesn't unnecessarily subject anyone to the violence of jail, and that honors constitutional and human rights. Finally, I hope we will continue to share the stories of people who inspire us and the stories of people who've experienced injustice that spurs us into action. Please remember and continue to share the story you've heard this week of Khalif Browder and his family, as well as the stories of Lavette Mays, of Marjorie Mock, of Eric Ogden, and Robert Cox. I will keep sharing their stories too, along with Delbert Tibbs, who the state of Florida would have executed because they thought he was so dangerous, but who wrote my law school recommendation letter. And Kirk Bloodsworth, who the state of Maryland would have executed, and who made my wedding rings that my husband and I wear. All these multi-dimensional, powerful, worthy people. Let's remember that there are millions more. And when we hear the stories of people impacted by this legal system in our work and in our communities, let's also commit to believing them, believing the pain and wisdom that come with having borne witness to something as terrible as mass incarceration. Thank you very much for your ongoing partnership, for your support, for your work, for everything you do to provide alternatives to our antiquated system. It was my distinct honor to be here. Thank you very much. Oh, sorry. It's like, what do we do now, everyone? We have some time, so if anyone would like to ask me questions, I'm here. Yeah. Sure, I see someone here. So the question was, why are we doing drug tests on people with pending cases?
Correct.
Well, I mean, that's a fantastic question. I may not be the one best equipped to answer it, though I would offer that the Ninth Circuit Court of Appeals several years ago had a case that noted that the drug testing of people based on mere accusation of a crime implicates the Fourth Amendment. It's essentially a search, and it could very well be an unreasonable search, particularly if someone had there's no articulable basis for thinking that drug testing is needed to mitigate a real risk. So I think it's a good question. I think it's a practice that we'll continue to need to really press against and challenge. Yeah. Sure. Oh, sure, that's U.S. v. Scott is that case, sure.
Can you talk a little bit about the Fifth Circuit opinion and the two judges she mentioned, and what in the world they were thinking when they put their ruling together?
Sure. Okay, so I wish I knew what in the world they were thinking, but I can certainly tell you a little bit about it. So for those who want a little bit of context, this is in the big bail reform case brought by Civil Rights Corps, O'Donnell versus Harris County, which has been pending. It's been up to the Fifth Circuit. The Fifth Circuit, in large part, affirmed the decision to enjoin Harris County's unconstitutional pretrial practices. Upon a second injunction order from the district court, the defendants once again requested an emergency stay of that injunctive order, essentially an emergency request to pause that order from going into effect. And so on that emergency stay request, so, you know, what I will be arguing next week in federal court, if asked this question, is this is a very narrow holding. It's sort of the best we can make of it. It applies specifically to this emergency stay and the scope of that second injunctive order. But what's very distressing about what those judges did is they applied a different standard of review. They applied rational basis instead of heightened or strict scrutiny. Very fundamental to these cases is that everyone in this country has a fundamental right to their liberty, especially pretrial, and that wealth-based incarceration in particular is constitutionally suspect and problematic, and that's been the case for decades of Supreme Court precedent. So these two judges, over a very vigorous dissent, essentially said that, well, there's no absolute right to pretrial liberty, and there's certainly no absolute right to affordable bail, and kind of conflated both the notion of having an absolute right with the fact that the government still must justify infringement on the right, which continues to be very squarely true, with the right to an affordable bail. So it's a very problematic ruling. It's one that we hope is going to get revisited by a fuller merits panel eventually. It's one that flies in the face of existing precedent, both in that circuit and Supreme Court precedent. But my understanding is that it was written by a recent, someone who's recently taken the bench, and so that is alarming. Yeah. I see a question over here. Yeah.
Thank you very much. I kind of wanted to understand what kind of, in your experience, besides DNA, what other aspects in your experience kind of help you with the exoneration with these people?
Sure. So,
as far as DNA and things like that, besides DNA.
Just to be sure I'm understanding the question, was it what things helped realize exonerations for people? So certainly the availability of DNA evidence starting in the 90s helped a lot of people establish their innocence. In Delbert Tibbs's case, it was the fact that he was ID'd as a potential suspect because after a witness who survived the crime gave a description of the perpetrator, she was handed a Polaroid picture of him and changed her testimony to say, oh no, it's him, completely different than the description that was given. In his case, the Florida Supreme Court essentially overturned his conviction because there was such a remarkable lack of evidence, and the prosecutor agreed not to retry him because the prosecutor was aware that it was essentially a fabricated case. There are other people who were convicted by bite mark evidence that has since been established to be remarkably unreliable. People who were convicted by some more rudimentary version of matching blood type, hair samples. A guy named Gary Gauger was really horribly, tragically, wrongfully convicted of murdering his own parents. And the way that they convicted him was after essentially interrogating him for 20 hours straight with very few breaks, after he's just learned that both of his parents have been killed, they convinced him to not give a confession, but give a sort of dream sequence version of like, okay, we know you didn't do it, but if you had, how could you imagine doing it? And they used that as a confession in his trial. So while DNA has been a helpful tool for many of these people, there are also kind of just the debunking of some of the bad forensics that were used in the underlying conviction, and sometimes witnesses coming back and admitting that the testimony had been wrong. Sure. So the question was about false confessions. I'll admit that probably the freshness of any stats I would be able to offer you is a bit rusty now that I'm focusing more on the front end of the criminal justice system. But false confessions are certainly real. There are DA's offices in the country that have given training, PowerPoints that people have uncovered about how to kind of use them in trial powerfully. There are police tactics of keeping people up and tired, like I was just describing with Gary Gauger. I know of at least his story where the false confession was pretty deliberately kind of please tell us how you could imagine doing it. Very young people or people who may have trouble tracking what the officers are asking are often considered to have made a false confession. It's certainly a reality that people confess to crimes they didn't commit, just like people plead guilty to crimes they didn't commit to end the ordeal and get out of jail.
If the average person wanted to be involved or help support the Innocence Project, what would be some good places to start?
Sure. I mean, I don't work for the Innocence Project, but I'm a fan of them, obviously. I would go, I mean, there's the Innocence Network website that has information about not only the kind of the well-known Innocence Project that's based in New York, but there are regional projects as well. Not every state has one, but many do. They're often operated out of law schools and depend on law students to staff cases. But I would refer you to the Innocence Network's website so you could learn more about some of the various projects that are out there. All right, I'm not seeing any more hands. Okay, I think we're done. Thanks again. I really appreciate this opportunity to be with you all. Thanks.